and also the pre-purchase program counseling portion, but like the IDA, the individual development account, and like our down payment assistance program, you would have to be under the 80% MFI as well. But for counseling, there's no income guidelines.
Is that same for your,
Why did it? Huh?
for the FPV
Yeah.
as well?
Mm-hmm.
Is this also information that if I went to your website would be there?
Mm-hmm.
Okay.
Yep, everything's on our website. You would have to complete an intake for any program as well.
Is this for the whole state?
It's for the city of Portland, except for the pre-purchase program and the foreclosure program, it's Oregon.
Is this program guide a person the entire way along? You know, there's a counseling set part that you described at the beginning of it, but, is there counseling throughout each step so people avoid pitfalls and, you know, things that get help with, filling out documents?
Yeah, we'll also talk to like your if you have a real estate agent or a lender, we'll connect with them as well. So it's throughout the whole way we're with you. Any other questions?
Do you do homeownership, owners insurance? Do you do insurance?
No, we don't.
Okay.
Yeah, we have a list of them. We could provide if anybody doesn't have.
Does your website also give like a history so you could see if things are actually improving? So that more, you know, people of Black or underprivileged people are able to get homes and get them in places they couldn't get them before.
Yeah, I'm not quite sure. But if we did have that, it would be under the About Us section. We could check that out. Any other questions? Okay, I think we will be doing a raffle. $50 gift card. Was anybody interested in the sign-up sheet? I can pass it around.
All right. So are we acting in a tour, or is she supposed to be here?
I think she's supposed to be here.
I sent her a Zoom.
I can double check it. Sure.
Okay, so. Raffle tickets. Does anybody have questions for Miss Asia? Oh, she's answered them already?
Yep.
How good is that? Okay. Peggy, Linda, there's yours. And let's see. You are Deborah, Gwen, okay, so that's yours.
ease and relax when you get connected with these people. Anyway, they are offering free estate planning services. So if you have property that you do not have registered or recorded, you haven't put it in a will or a trust, and you're wondering how you can do that to leave it to those who you most want to have it, connect with them. I encourage you to get their number and call and ask about the estate planning services. A lot of times we think about doing this and then we say, well, I'll do it later. Well, you never know when that time will come that you need to have had it done. And then there's confusion and turmoil in families. Sometimes there may be an ex-spouse that ends up with property you wanted to go with to your children. So it's good to revisit these things from time to time. Also realize that, like your life insurance, if you've got a life insurance contract that you've said to the insurance company, pay the proceeds out to my children, but in a will you've got it going to your ex, there's going to be turmoil. So revisit these things from time to time. Consider what you have done in the past and whether or not it's still relevant.
We're ready.
We're ready. Okay. See, you be anxious for nothing. That's a good thing. There she is. Miss Akua, how are you?
I'm good, how are you?
Wonderful, thank you. Thank you for joining us. Your audience is primed and ready.
Okay, can I share screen now?
Yes.
Yes.
Okay, thank you. Okay. You have to enable screen sharing.
I didn't hear that.
Whoever's the host has to enable screen sharing. I can't share my screen. Free estate plans for people who are homeowners and who are income qualified through this program. And kind of the purpose of this program is to ensure that we don't lose further Black homeownership or Black wealth in Portland, because I think you've dealt with enough. So I'm so glad you're here and you're interested and wanted to learn more about this. And before we get started, I need to remind you that this is general legal information meant to educate, not legal advice. Right now, I'm not your lawyer until you sign an engagement letter, basically, is what I'm saying. So that being said, let's get into it. So this webinar is designed to educate you about the basics of estate planning. We're going to briefly talk about the current status of Black wealth in the United States, why estate planning matters, reasons why people don't create an estate plan, and then a basic estate planning tools. I might have to abbreviate some of this because I do have a 2:30 I have to get to across town. Your business, your clients, or your community. Or does leaving a legacy mean to put an effective plan together such that things don't fall apart the moment you leave this earth? In what way is your legacy important to you, or your family, or your community? Those are my first probing questions there. And then it's probably no surprise to you that black wealth, I should say the wealth gap in general, has been increasing in this country with more wealth concentrated in fewer people, and that communities of color are the most unequally impacted by this widening wealth gap. And the pandemic has made this far, far worse. In 2016, the wealth of a white family was about 8 times greater than that of a black family. And I've been keeping up with making sure the research is current, and that has stayed fairly constant. Homeownership accounts for about 25% of all that wealth. And then 54% of black wealth is tied up in home equity. So it makes sense that if the black community loses homes, then they lose that wealth. According to a study done by Portland State University, about black family income in Multnomah County is less than that of white families, and the poverty rate amongst black children is about 50% compared to 13% for white children, which seems incredibly high to me. I'm not sure. That one I want to relook at again. I feel like that doesn't seem right, but that's what the study told us. And about 1/3 of black families in Multnomah County own their homes, compared to about 60% of white families in Multnomah County. So, lots of work to do. Let's take a good look at this figure. About over the last 100 years, the last century, the black community has lost nearly 3.8 million acres of land, valued at about $6 billion, in part due to people dying without a will, and the state selling off and dividing that property. The state keeps the proceeds of those sales only when there's no will and the heirs of the person who passed away aren't found. It's not as common, at least as far as I know, at least in the state of Oregon, for that to be the case, unless, of course, there's absolutely no record of your family members existing and they just can't be found. It's happened, but not super often, thankfully. So, also, interestingly enough, about 53% of white adults have wills, and about 28% of non-white adults have wills. So, they grouped the non-white folks together. That's how few folks have wills in the non-white community, which is crazy to me, but also not, considering how much wealth has been stolen, how much we've been excluded in all sorts of avenues when it comes to building economic wealth. It's not that surprising, really, if you think about it. As we will learn, estate planning facilitates the transfer of wealth from one generation to the next by passing on money, personal property, and your home. Now, this poll is not intended to shame anyone, but to get a good sense of where people's minds are. And normally this would be done virtually, so I'm not going to give any answers from this, but that's okay. I'm going to ask it anyway. And the question is, do you have an estate plan? A, yes, I'm on it. B, no, but I'm in the process of getting one. And C, no, sorry. And that's okay, we don't have to answer that out loud right now. So these facts are pretty troubling. Economically, we've been set back quite a bit, and they bug me. I want to acknowledge that the disparities in wealth are not due to anything that we have done necessarily, but like I said, we've had entire Wall Streets and even more tight-knit communities prior to having our communities torn down. But I'd love it if folks were more aware of the ways to protect the assets we do have. Targeted estate planning for the Black community is one critical step towards helping fix this problem, and part of my goal is to make estate planning understandable and accessible. And I want you to know that these tools are a priority and are within your reach. With that in mind, with that background information in mind, let's talk about why estate planning is especially important to us. Above all, it can accomplish the fact that we can transfer wealth more easily without losing it to the courts or to attorneys after death. You want to pre-plan to avoid the loss of money that would go to the courts. Planning also ensures that economic assets stay within your community, that money is being used towards starting more businesses or making sure that those who don't have what they need in the community and the schools get what they need. And you don't have to start from scratch every generation. That would be great. Planning gives the immediate beneficiary the money inherited, but also prevents homes from being sold off or people being forced to move out of family homes. As a person who personally lost grandma's house before I became a lawyer, it's very personal to me. So not having a plan in place can lead to dealing with unexpected parties and costs, like I said, and with no control over who inherits. Because if you have people you are estranged from, or people who are not great with money and they inherit it, then that's just a loss, unfortunately, which is why we like to have the plans put in place so the money goes exactly where you want it to. Families with modest means can least afford the consequences of passing away without an estate plan. So here are the few reasons why people don't create estate plans. Assuming things will be passed on automatically after death. I know certain people will inherit by virtue of the law, that doesn't mean it's going to happen automatically. Assuming you'll inherit a piece of property just because you live in grandma's house, which was my assumption before I went to school. Distrust of the legal system, which the legal system has earned in spades. Inability to afford legal services to create an estate plan. Again, very fair, because legal services are not necessarily always accessible. And finally, the belief that estate planning is only for wealthy people who have a lot of money and items to pass on. We're about to break that myth. Oh, no, finally, it's because of procrastination. Because even if you do have the means to create a plan, a lot of folks don't. You see Aretha Franklin pass without a plan, Prince passed without a plan, Snoop Dogg doesn't even have a plan in place. He thinks it's going to be funny to watch his family fight over his assets when he's dead from heaven. That's not funny. As the lawyer, I can tell you it's not going to be funny. It's not. It's a good idea to have a plan in place. Now that you've learned a little bit about the current status of Black wealth, why estate planning is important, and why people don't create plans even when they have the means to do so, let's talk about what exactly is estate planning. So estates are not just for rich folks. I think the word estate leads people to believe that tremendous wealth is required to create a plan. An estate is just the property that you own, individually or jointly with another person like your spouse. Your estate includes real estate, vehicles, bank and retirement accounts, jewelry, even your pet is part of your estate because it's yours, it's your property. An estate plan is a set of legal documents that describes three things. One, what you want to happen to that property when you pass, who you want to be in charge of making sure those wishes are carried out, and three, what happens if you become unable to take care of yourself while you were alive. And I'm going to cover these documents with you today. Your last will and testament, a revocable living trust, a power of attorney, an advance directive. So the will is a legal document that becomes effective only when someone passes away. It explains, like I said, who will be in charge of your estate, how your final debts and expenses will be paid, and finally, who will inherit your money, your assets after you've passed on. So a will is important because it gives you control. Otherwise, your assets will pass by organ law. For example, if you die without a will, and you have a spouse and kids from your previous marriage, the assets will be split 50-50 between that surviving spouse and those kids from that previous marriage. Or as another example, if you are unmarried to a life partner or have a blended family, organ law may result in your assets being distributed a little differently than you would have liked. Luckily, it's easy to avoid this by creating a will, trust, or a beneficiary designation for an asset. Scenarios like this are an example of how these laws may or may not reflect how you would have liked your property to pass on, which is why it's usually better to have a will. Another important feature of having a will is that you get to name somebody to be in charge. You have the power, the control to name somebody to be in charge that you trust, and that you get to name a guardian to care for any minors that you cared for while you were alive. Even if you don't have many assets to plan for, if you have kids, naming a desirable guardian is one of the most important reasons you would still want to have a will. Who's in charge of the will after you pass on? It's the administrator or the personal representative. They are supposed to make sure that they carry your wishes out stated in your will. And you may wish to name an alternate personal representative in case the first person you name is unable to serve. If you don't name an alternate personal representative, the courts will do it for you, and it may not be the person you want in charge of things. Since this is an important role, so it's a good idea to talk to your loved ones and make sure whomever you appoint is willing and able to carry out your wishes. If you have a will, can you avoid probate? The answer is no. A will does not effectuate the transfer of property. Either a trust or probate does that. A will just state your wishes and appoint somebody to handle those wishes, but it doesn't say, oh, because I've written my will out, this is being transferred over. No, the transfer of property is only handled either via a trust or through probate. Or if you're very smart, you have your beneficiary designations all up to date, and that solves that problem for certain accounts. So probate notifies potential creditors and heirs of your passing. It confirms debts and expenses are paid, and like I said, it transfers title or ownership of assets. It requires, depending on the type of case you have, if you have a complicated situation, court supervision is usually required unless you have, like I said, a trust or your beneficiary designations are up to date. Like I said, the clear title to land is when it's needed. If somebody owed a lot of debt to the deceased person and they need to collect on that, sometimes court supervision is needed for that. If there's a dispute as to who's entitled to the assets, or if you're wanting to contest the will because you think, oh, Grandma had Alzheimer's at the end of her life. She didn't create no will. Who did that? Who did that with her? Court supervision. That's when you need probate. When things are going south like that. Another way to protect and maintain control over your assets is through a revocable living trust. A trust is like a bucket that you put all of your assets into during your lifetime. You title all of your assets into the name of the trust, so that when you pass on, all that has to be done is the trustee takes control of those assets for you, manages them, makes sure that they are passed on to your next of kin, if that's what you're looking for to happen, or if you want them going directly to your grandkids, or if you want that money to only be dished out when they turn 18, 25, 30. There are people who wait until their kids turn 35 and 40. It's like if they think they can't handle it, that's their wish. Those are their instructions. They can make it so. If you know your child struggles with addiction and you only want that money going to them to either help them with rehab or to wait until they're put together, or if you're like, well, if they can't get it together, give it to their kids or to someone else. That's what the trust solves. It gives you control over how those assets are managed. It doesn't just say, give them to them outright unless that's what you want. It gives you a little more control over what happens after you've passed on. You can also name an alternate successor trustee in case the first person you name is unable to serve. It's a good idea to have people in place as backups, or people will have to scramble to find new ones. Probate is a public process, so trust can be a good alternative if you desire privacy in the way your assets are distributed to the beneficiaries. If you have just a will, the probate process for probating a will is very public. People can look things up usually, and that's why we receive calls from people interested in buying the house. Oh, I learned this person's passed away, and I would love it if you were interested in selling that house, let me help you with that. I get phone calls like that all the time now. It's a public process. Another document that can help you achieve your estate planning goals is the power of attorney. A power of attorney is a tool that helps you protect your assets while you are alive and able to manage your financial matters due to serious illness, injury, or disability. So a power of attorney has two parties, a principal and an agent. The principal is you, the person creating the power of attorney, and having the power to appoint somebody to manage your finances. The agent is the person that you've chosen to manage your assets while you are alive. They have to be anyone who is 18 years of age or older and who is of sound mind. If they have a mental health issue or something, if they have if they're differently able, to put it that way, then it's probably not a good idea to appoint them as somebody who can be in charge of your money. You'd want to talk to the agent beforehand to make sure that they understand your wishes and that they are fully aware of the kind of power they have over your property. And also, I recommend that if you sign a power of attorney, you read it very carefully, because you're handing this person the power to basically bankrupt you if you don't trust them with your money. That's why you have so many financial elder abuse cases. It's because this person has, sometimes they've chosen the wrong person to be in charge of your money. And then they take all that money for themselves. Self-billing is technically not allowed, and they can be sued later on, but sometimes you can't get that money back. So I'm saying, basically, really think hard about who you want to be in charge of managing your finances. It's somebody who you think would never even consider going crossways with your money like that. Think really hard about it. It's also a good idea to name an alternate in case the first person you choose is not able to serve. Because, again, if you don't choose somebody, then actually that's the next slide. Or the slide after that. That's okay. I'll get into that in a second. The agent can do a couple things on your behalf. If you got into a car accident and couldn't manage your finances for a few weeks, a few months, agent can pay bills. If you have it like that and have multiple pieces of property and need extra long-term care, they can sell your extra house to make sure that your funding for your health care is taken care of for the next few years or months. And they can file taxes on your behalf if that's what you need. Any other guideline you specify, like, oh, please collect my mail, they can do that for you. The agent's authority over your assets will end when you revoke the power in writing. When you've gotten back to your full health and you're able to revoke that power, you can do that. Or when you pass away, that's when that power ends. And at that point, the estate administration process should begin with somebody else. So I'm going to get to the part what happens if you don't have a power of attorney set up. If you are needing help with your finances and you've lost capacity, your family may have to petition the court to set up a conservatorship and hire a conservator. That's an expensive process. You'll have to hire a lawyer, petition the court, like I said, deal with possible delays in getting what you need and privacy invasions, because they have to know all of your business to get this set up for you, basically. It's time consuming and very expensive, so it's really worthwhile to invest in putting a plan in place ahead of time, even if you never end up needing it. This is what happens, a need for a conservatorship arises if you don't have a power of attorney set up, or if you have a power of attorney set up and don't have an alternate named, then you might have to go to the court to find another one. It's just a huge waste of money if you can get your hands on a good power of attorney. So, bottom line is having one in place can help them avoid the need for a conservatorship. Third poll. How confident are you that you or your loved ones know what to do in a medical emergency or when someone passes away? A. I'm confident. They know what they're doing. B. Ooh, I'm not so sure. Or C. I'm not confident at all. Something to think about. You know, I might skip this story because I'm running out of time, but I might have to tell you guys the story later. It's pretty sad, basically. This family had a plan in place when Matt Choi passed away due to being killed in a home invasion. And I was just saying how important it was that they had that plan in place, and the business is still going. Mama is running it and thriving in different stores across the state of Oregon because they had a plan in place, and she was able to grieve on her own and regroup herself. As we switch talking about the Healthcare Advance Directive, I wanted to share 2 important facts with you. According to the American Bar Association, Black elder care representative, and this person will make decisions regarding your medical care. Excuse me. Your healthcare representative can also advocate for you, in a medical situation. For that reason, you should select somebody who is willing to serve in that role, not somebody who you think should belong in that role, because they could easily decline to serve in that role. Put somebody in that role that you trust to follow your wishes. And you have the ability to name alternates in case the first person that you name is unable to serve. So, a couple of factors to think about when choosing somebody. Is this person assertive? Because they may have to fight with the hospital and with family members to enforce the wishes that you had laid out in your form. If you foresee the possibility of a conflict in enforcing your wishes, please be sure to choose somebody who is strong-willed and assertive, who will not back down, unless, of course, it's a good idea to in making sure your health is in place. Does this person live close to you? While you don't necessarily have to be in the same city or even the same state, location can be critical if you're dealing with a long-term illness, and you want to make sure the medical personnel are abiding by your wishes. This person may need to be present. So if that's a factor, then it's a good idea maybe to choose somebody who does live close to you. And the third factor is if this person will also be your financial agent, your power of attorney agent. If you have two different people serving these roles as the healthcare representative and as the power of attorney agent, make sure they get along well because they may have to work together at some point. You don't want anybody stalling payment for insurance or interfering with medical bills. That would be the worst because the person who deals with the finances will be dealing with that. So you want to make sure they can communicate well together. That can be very helpful. Here are a couple of decisions that are covered by the advance directive. I had to put a couple of pictures of animals on there just so it's a little less depressing. They cover resuscitation, tube feeding, comfort or hospice care, mechanical ventilation. I'm sure most of you are familiar with these concepts and having to make these decisions eventually. They let you cover it and they let you explain in great detail what you would like to be done. If you have a lot of thoughts you would like to put on paper, they allow you to do that. I know it's deeply uncomfortable to think about these things, but it's really important to have a conversation with your loved ones about what you want in case you're unable to communicate with your doctor. Most people will reach a point in life where they can no longer communicate for themselves, and no one can predict when unexpected medical situations can happen, and they can happen whether you are young or you are old. My mother is a nurse who had her first heart attack, the first one, around age 50, pretty young. So, like I said, it can happen when you're pretty young or older. And when this happens, doctors hope to provide the treatment that the patient would want when your wishes aren't clear. With an advance directive, you can make them clear and potentially avoid a great deal of family tension and conflict, which, as a person who's been through that multiple times with my mother's family, I have to say it's very near and dear to my heart to have any guidance at all when it comes to medical situations. Thankfully, she's given it to us. So, yes, I'm a big advocate of making sure your wishes are written down somewhere and they're clear. Make sure you update your advance directive when anything is happening in your life. That's a big deal. If your health is declining, if you marry, separate, or divorce, if your spouse passes away and you have no wishes, if you have a new person you want to appoint as your healthcare representative, that's the time to do it. You don't want your old healthcare representative up there if you've been divorced, and you don't want your ex-husband or wife on that thing. No, you don't. So make sure when big things are happening in your life, think about, what do I need to update right now? Oh, this is the time. And a couple of other considerations to think about. If you're not feeling confident that you can afford or can make just too much money to qualify for the homeownership asset preservation program right at this time, here are a couple of other considerations that might be good to put in place in the meantime. Joint ownership provides a simple and easy way of avoiding probate when the first owner dies. To avoid probate, you take title as joint owners with someone else, and when the first person dies, the surviving joint owner takes the house. No court involvement is required. And with bank accounts, with bonds, or securities, you have payable on death accounts or transfer on death accounts. That just allows you to name somebody to inherit the money in either of these accounts. When you pass away, all they have to do is show proof of identity and a death certificate. And usually that money can just pass on very easily. And last but not least, you have your beneficiary designation, your life insurance, right? Your retirement accounts. If you have those in place and you want to make sure those are updated, so all they have to do is again show proof of identity and a death certificate, and that money can pass on automatically. So we have a streamlined, easy process for making sure that the money goes where it's supposed to go instead of having to go through the courts. It's a huge waste if you can get it done simply. So these are a couple of ways you can get it done very simply. What to do next? This is your time. At the end of today's presentations, if you are interested, you can sign up with Asia. Thankfully, she's there with her sign-in sheet. Thank you so much for bringing that. And if you're still interested and haven't signed up, give us a call at 503-595-3517, and we would love to help you. This is the whole purpose of this program. Ready for you. And normally I would take time for questions, but unfortunately I do have to head off to another meeting across town. So I deeply appreciate you giving me this time to speak with all of you and listening to me drone on. And I look forward to helping so many of you out and getting people's plans in place. I think this is our revolution for making sure we have all of our economic assets in place and getting our wealth back to where it was. Thank you so much, Ms. Patricia.
I do apologize, the sound quality was not quite what we would like, but are there anyone have a question for her? Miss Peggy? Yes. Here.
I'm just wondering if someone has a business, they're entrepreneurial, that these same things that apply to property, home ownership, they also apply to business ownership?
I would say in a different fashion, but because the assets are different, individual assets, you have direct choice as to who to leave them to. Business assets, there may be underlying business documentation that says, what belongs to who. But in that case, there are strategies that you would set in place to divide those business assets appropriately. Nonetheless, it should all be done legal. It should all be done in conversation between partners or owners, and it should all be recorded. Okay. Any other questions? Well, okay, we thank Ms. Akua for chiming in there. As I indicated, the process of planning your estate isn't simple. It's challenging to think about who in your circle you would trust with everything you own. Be willing to think about turning it over to them. And the biggest part of that is being realistic about where you are in life. If you recognize your health may be declining, or that you just realize you want to set this in place before something happens, that's the biggest piece. Do it before it's too late. So I guess with that being said, we will move on now to our next presenter. We have, oh yes. Yes.
If you're planning and you're wanting to designate a power of attorney or whoever you're designating.
Yes.
And you want an alternative, is it a good idea to have an older person and a younger person?
If you'll repeat that for the group.
If you're choosing your representatives, and you do want an alternative, so you have two in mind, I think of somebody that I know who would be very good, but they're older, and so they may even die before me.
Right.
So I'm thinking a younger one would be a good alternative, right? To make up both the younger and the older.
Yes. Peggy, that's a very good question. And as Akua said, you should have a primary consideration and a successor consideration in the event your primary choice is not able or willing to continue. And you should have this conversation with both of these individuals so they know you're thinking to have them come in and do this for you. This is a big job and they may not be willing. So, yeah, it's definitely a conversation thing, but don't sign them up without talking to them about it. Okay? Did you have a question? Okay. All right, very good. Thank you. Okay, any other questions? All right.
What else on the intake list?
Intake list.
What intake list?
Okay, yeah. She can sign you up, that's great. And then they'll be expecting to hear from you. Okay. All right, we would like to invite Mr. Byron Blunt to come forth and present on behalf of his